Well, moving on now, and it's the verdict the world is waiting for as the defamation case between Johnny Depp and Amber Heard has come to an end. Both teams delivered closing arguments today that echoed much of the past 6 weeks of trial.
Johnny Depp is suing ex-wife Amber Heard for $50 million, alleging she defamed him in an op-ed published by The Washington Post. In the op-ed, Heard referred to herself as, quote, a public figure representing domestic violence.
Each side has sought to present the other as an abuser during their 5-year relationship, and now it's up to the jury to reach a final decision on who will be handing over millions of dollars. That's expected to come early next week.
Cheers, everyone.
I want to move on with my life. I have a baby. I want to move on. I want Johnny to move on too. I want him to leave me alone.
Ridiculous, humiliating, ludicrous, painful, savage. Have never in my life committed sexual battery, physical abuse.
To reach a new audience, it constitutes a republication. Further, if you find a republication occurred on December 19, 2018, then in order to find for Mr. Depp against Ms. Heard, you must also find by clear and convincing evidence that Ms. Heard made this republication with actual malice. A principal is a person or legal entity with power or right to control the means and methods of performance by which another person performs the principal's work. An agent is the person who is subject to the power or right of a principal to control the means and methods of performing the work. An attorney has the express authority to do everything which the client expressly authorized him to do, and the implied authority to do everything necessary or incidental to the purpose for which he was retained. Ms. Heard has the burden of proving by the greater weight of the evidence that Mr. Waldman was an agent of Mr. Depp, and that Mr. Waldman was acting within the scope of his agency when he made the statements. You must remember that there is no burden on either party to prove the truth of any of the statements. Both parties were free to offer proof of truth, but by doing so, they do not assume the burden of convincing you of the truth of the statements. The burden remains on each party to prove that the statements he or she complains of are false. The rules of evidence ordinarily do not permit witnesses to testify as to opinions or conclusions. An exception to this rule exists as to those whom we call expert witnesses. Witnesses who, by education and experience, have become expert in some art, science, profession, or calling may state their opinions as to relevant and material matters in which they profess to be expert, and may also state their reasons for the opinion. You should consider each expert opinion received in evidence in this case and give it such weight as you may think it deserves. If you should decide that the opinions of an expert witness is not based upon sufficient education and experience, or if you should conclude that the reasons given in support of the opinion are not sound, or if you feel that it is outweighed by other evidence, you may disregard the opinion entirely. In considering the weight to be given to the testimony of expert witnesses whose opinions differ, you may consider the ability and character of the witnesses, their actions upon the witness stand, the weight and process of the reasoning by which they support their opinion, their possible bias in favor of the side for which they testify, the relative opportunities for study or observation of the matters about which they testify, and any other matters which serve to illuminate their statements. In considering the weight to be given to the testimony of expert witnesses, you should consider the basis for his or her opinion and the manner by which he or she arrived at it, and the underlying fact and data upon which he or she relied. An expert witness was asked whether statements contained in published treatises, periodicals, or pamphlets are reliable authority of a type normally relied upon by others in his or her field of expertise. This evidence is permitted to test the knowledge, accuracy, and opinions of the expert witness. And if such evidence is established as a reliable authority by expert testimony, it may be considered by you along with the other evidence in the case. In considering the evidence, you are not limited to the bald statements of the witnesses. In other words, you are not limited solely to what you see and hear as the witnesses testify. On the contrary, you are permitted to draw from the facts which you find to have been proven such reasonable inferences as may seem justified in the light of your own experience. During the trial of this case, certain testimony has been presented to you by way of video depositions. You should give this testimony the same consideration as to its weight and credibility as you give to the testimony of witnesses who testified here in court. You must not discount any testimony merely because it was shown to you by video recording. When one of the parties testifies unequivocally to the facts within his or her own knowledge, those statements of fact and the necessary inferences from them are binding upon him or her. He or she cannot rely on other evidence in conflict with his or her own testimony to strengthen his or her case. However, you must consider his or her testimony as a whole, and you must consider a statement made in one part of his or her testimony in the light of any explanation or clarification made elsewhere in his or her testimony. Any fact that may be proved by direct evidence may be proved by circumstantial evidence. That is, you may draw all reasonable and legitimate inferences and deductions from the evidence. If you believe from the case that a witness, other than Mr. Depp or Ms. Heard, previously made a statement inconsistent with his or her testimony at this trial, the only purpose for which that statement may be considered by you is its bearing on the witness's credibility. It is not evidence that what the witness previously said was true. If you believe from the evidence that Ms. Heard or Mr. Depp previously made a statement inconsistent with her or his testimony at this trial, that previous statement may be considered by you as evidence that what Ms. Heard or Mr. Depp previously said was true. In reaching your verdict in this case, you are to consider the testimony and evidence. Sometimes attorneys stated objections during the course of this trial and instructed a witness not to answer a question. Objections and instructions to witnesses are not evidence, and you may not consider them in reaching your verdict, nor are you to draw any inference from the fact that an objection was made. You must not consider any matter that was rejected or stricken by the court. It is not evidence and should be discarded. Any amount of damages requested by a party is not evidence in this case. You should not consider it as evidence in arriving at your verdict. If you find your verdict for Mr. Depp or Ms. Heard, then he or she is entitled to recover compensatory damages without any proof of actual or pecuniary injury. As a result, injury to Mr. Depp or Ms. Heard's personal and business reputation, humiliation, and embarrassment is presumed. If you find either party liable for defamation, then in determining the amount of damages to which the opposing party is entitled, you may take into consideration all the circumstances surrounding the defamatory statements, the occasions on which they were made, and the extent of their publication, the nature and character of the insult, the probable effect on those who heard the statements, and their probable and natural effect upon the defamed party's personal feelings and upon his or her standing in the community and in business. Your verdict should be for the amount that will fully and fairly compensate him or her for, number one, any loss or injury to his or her business; number two, any insult to him or her, including any pain, embarrassment, humiliation, or mental suffering; number three, any injury to his or her reputation; and number four, any actual out-of-pocket losses that were caused by the statements. Mr. Depp cannot recover damages for any harm that occurred after November 2nd, 2020. Ms. Heard can recover damages for any harm that occurred after Mr. Waldman's statements were published. The burden is on the party seeking damages to prove by the greater weight of the evidence each item of damages he or she claims and to prove that each item was caused by the defamatory statements at issue. Neither party is required to prove the exact amount of damages, but the party must show sufficient facts and circumstances to permit you to make a reasonable estimate of each item. If either party fails to do so, then he or she cannot recover for that item. If you have found by clear and convincing evidence that the statements in the op-ed were made with knowledge that they were false or so recklessly as to amount to a willful disregard for the truth, that is, with a high degree of awareness that the statements were probably false, then you may award punitive damages to punish Ms. Heard for such actions and to serve as an example to prevent others from making such statements in the future. You must state separately in your verdict any amount you allow as compensatory damages, if any, and the amount you allow as punitive damages.